relative to the information about Mr. Colin Albert.
Certainly, Your Honor. Read this, so I apologize, I'm going to read down what Mr. Attorney Maddie did. So prior to the hearing, he had contacted the base asking about the inquiry that we discussed on the hearing June 22nd. On June 23rd, he received a call from a private Jordan Rosa in the Legal Service Department at Fort Jackson, and he indicated he was returning a call to place last week. He made the request to Private Rosa about getting access to Mr. Albert, who, by the way, at this time, shortly after the hearing, he's now in basic training. So the 10-week basic training, the first 3 weeks was the initial school. He's passed that. He's now basic training at Fort Jackson. Private Rosa indicated that he was unaware of what process it would have. On June 26, 2026, Attorney Maddie received a call from Sergeant Lucas Vaughn at the Trial Defense Services in Fort Jackson. He indicated he asked about getting access to him from basic training for purpose of subpoena. He was told, quote, "That's not happening," is what the sergeant said. He speculated that the only possibility would be a 30-minute phone call. He said that the training regimen for basic training is very specific and condensed. He advised that eating and sleeping are the only breaks that the trainees receive. He said that following his graduation from basic training or advanced infantry training, which is what he's doing, he'll be a permanent party member at a duty station. He's more likely to have access for a deposition at that time. On June 26th, Attorney Maddie received a correspondence from Colonel Jacqueline DeGain, basically suggesting that he would need the identity of Colin's commanding officer. We've now made several requests.
Thank you. Attorney Seligson, is that news to you, or have you had communications with?
I would think it's news to him, because he might not know, because we were preparing this to get, and then we got the notice about coming today. So I kind of ran today. We had responded on the search terms. We did talk about search terms for Colin Albert.
Okay,
so we hadn't had the chance to fill it in.
Why don't you reduce that to writing and let Attorney Seligson know so he can be prepared to make an informed response.
Thank you, Your Honor.
Just talking about it at this time.
That's right. I wasn't aware of the mechanics of where he is, but we are working productively on the search terms and narrowing the scope of the subpoena.
Okay.
So that's working productively.
All right. Attorney Tuxbury, you're welcome to stay, but on a Friday afternoon, you're welcome to leave, too.
I appreciate that, Your Honor. I think I'll take the invitation to depart.
Okay.
Enjoy the rest of your day, Your Honor. Thank you very much.
Thank you. So the other remaining motion is the plaintiff's motion to compel Ms. Reed to produce additional information and discovery. And I've read everything. Mainly the issues relate to medical information and financial documents. And I guess I'll start with Attorney Seligson to ask you, given you know what the standard is, because your office has quoted it a number of times in your motions to compel, that parties may obtain discovery regarding any matter not privileged which is relevant to the subject matter involved in the pending action, whether it relates to the claim or defense of the party seeking discovery or the claim or defense of any other attorney. Your opposition uses the term fishing expedition, which that's great if it's a criminal case, because that's where fishing expeditions are discouraged and not allowed under Rule 17 under the criminal rules. But this is a civil case, and Rule 26 is very broad. So without getting into the specifics about the medical, why isn't merely the provisions of Rule 26 applicable here, and why shouldn't they require production of the information the plaintiffs request?
Your Honor, with respect to seeking her medical records for a 2-year period, even though the term fishing expedition generally applies in a criminal case, I don't understand why they would need to understand her health in 2020, 2021.
How about 2022?
That's different. Perhaps they, if they narrowed it, we could reach an agreement about something in confidence. But
Did you have discussions about narrowing it? Did you two have discussions, or were you talking with someone else on these?
I spoke to Attorney Rosenberg.
Okay.
but
Hang on. So the next issue relates to the financial documents. And there has been certain information provided. There's been certain information redacted. Have you had discussions about that?
we have had discussions, Judge. The redactions are for transactions that are not specifically asked for in the document request. So what we did was we produced the bank statements and credit card statements for the 2 dates that were asked. We blacked out and redacted account number and private information.
But somewhere you cited attorney-client privilege, I think, on that issue, which I had difficulty following.
Attorney-client privilege? I don't believe we assert attorney-client privilege, Your Honor. If there is a payment to counsel, then that's what that would pertain to. And if that's reflected on the
Somehow I don't think counsel were getting paid by credit card at that
Well,
time. Just a wild guess.
But there's a bank statement as well, Judge. So I don't have it in front of me with all transparency, but that would be the reason for it. The transactions that they asked for on the dates in question, we've given it to them. But just this broad wondering what else is out there and what else my client is spending her money on, it's not relevant, Judge. And she's entitled to some privacy on that front.
Right, but again, Rule 26 is so broad, it's not necessarily up to the party to say it's not relevant, because the standard is it might lead to the discovery of admissible evidence, right? So if we had a party every time just saying, well, it's not relevant, forget about it.
But if
Doesn't
they're asking,
work.
but if they're asking for transactions, if they ask for transactions on January 28th and January 29th, and the statement covers January 1st to January 31st, we've redacted out things that aren't specifically asked for.
All right, well, so we'll give Attorney Diller a chance. Do you believe that there was information redacted on the 2 days in question that is relevant?
Respectfully, I apologize. I don't have that redaction in front of me. I know that as it relates to anything on those 2 days, I believe there should be no redactions, and if things need to get filed that should be protected, we are amenable
Oh, hang
to
on.
redacting those
Don't
out.
have it in front of you. I'm sure you have a copy there.
I don't have it in front of me either, Your Honor. It's his motion.
My motion is, the interrogatory is a separate question from a production of document. So in the interrogatory still remains unanswered. The production of document is a separate whole issue that we have an outstanding issue for production documents. I acknowledge that there was something that was turned over through production of documents relating to financial transactions. Our request asked them to articulate under oath, every one of the transactions that she had and the institutions that she filed them for those 2 days so that we can track both her whereabouts and also whether it's reasonably calculated, lead to discovery of admissible evidence, which is significant for just a 2-day period of time.
Okay.
In response to that, Your Honor, as we are entitled to under the rules, we are entitled to say, here are the documents that answer your question with appropriate redactions for things that are not asked for in the interrogatory.
Let's go back to the medical issue for a second. Doesn't sound like the two of you have spoken about the medical issues. And you suggested there might be a limited period of time that there could be some agreement on. So I'm going to ask counsel to go talk about it. And I'm going to ask counsel to keep in mind the reference by Mr. Diller to the testimony from the criminal case and the forensic scientist relative to medications. Cited on page in their reply, I think.
Page 2 of the reply, Your Honor.
So I'm going to give you a little time to go talk about that. And hopefully you'd also take the time to talk about the other financial records. All right? If
Will
you
do,
can't
Your
do it, you come back, I'll hear you, and I'll issue a decision at some point. Okay?
Okay, thank you, Your Honor.
Great. Thank you.
Court, all rise.
All right, can you hear me? I don't know if you can hear me or not, but they did go over the part of Colin being in basic, and then they went over the part that they're still trying to get the documents, and with them, they're also trying to get the sorry if you guys hear my dog snoring, but they're trying to get the documents from Colin at least before they're probably going to have to do his deposition after basic, so they're going to have to ask for an extension for that. And then they did her medical records. They were wanting her medical records, and they don't think that it should be the past 2 years. So that's what they're talking about now. He sent them out to go talk so that they can discuss for what happens, what they actually separate, and what they actually get. If that helps.